Hi guys, it's Kathy. I hope you're doing well. Oh, a new week. Oh, a new week of courts open up. I don't know what I'm gonna do. Do I get a whole bunch of little clips? Maybe I should go to Harris County and get a trial from upstairs. What do you think? I know where they are. Maybe I should try to get something that's upstairs today. I mean, it would be great if I could research and see who we saw and then when their case is and which court they're going in. But that's not what I'm going to do. I'm just going to click around and find something upstairs today. Hopefully, it's a nice little trial. Hi, Salty. Who did I see that came in? Horsefish. Hi, Horsefish. Haven't seen you in a while. Where's Fozzie? Fozzie's sleeping, I bet. Kelly asked how I knew it was her. She knows. Kelly's always first, every day, almost. And today I was first. We're getting closer to Judge Fleish's birthday. So if you haven't sent a card yet, you have time. You have time to make a difference. Every card makes a difference. All right, let's see if I can play some clips today with sound. That would be a nice change, huh? Oh, I am, yeah, I'm a bit sleepy. It was two doubles in a row. I wish I could split them out. Oh, I hate when it does that. I can't fix it. How bad is the delay? Okay, let me try something. Wish me luck. Before I do that, hold on. Before I kill my live, let's open it over here just in case. I'm trying. It's making me jump through hoops to sign in here. All right. All right. Now I'm in twice. All right. I'll be right back. Nope. I don't think it fixed it. Is it any better now, guys? I'll just talk for a bit and get out of here. Leave. There we go. There's nothing I can do about it right now unless I kill the stream. Even if I kill the stream, I don't know if the next stream is going to do it. This software has been doing this a little bit more and more lately, and I've rebooted and I've everything. Changed browsers, cleared my cookies. It's just, it'll be okay. Now I have to share my screen again. It's my fault. Bill gave me a different software to use. Software he uses, and I haven't looked at it yet. I'll do it today. I've off today, guys. I'm off today. I'll find defrag. Yep. Scan disk. Scan disks and defragged. So we're going to Judge Pettis first. Not Pettis, Claymore. We're going to Judge Claymore first. And then I think we're going to go to another judge that acts and looks a lot like him. And I always get them confused. But I'll, you guys can help me figure out who is who in the future. I got my first MCP from Windows 98. Yep. Microsoft Certified Professional. Yes, I was back in the day. Don't worry, there's sound. Don't worry.
Samuel Gaines. This is State of Indiana versus Samuel Gaines, 64D02 2402 F51027. Defendant appears in person with defense counsel Voga. Stage present by Deputy Peterson. We're set for sentencing today, Judge.
Will you raise your right hand?
I write code.
Do
That's
you
what I
swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Hi, Willie. Okay, hi, Terry.
I'm going to save everybody some time. I'm trying to find the right page. The plea is rejected. The basis for that is simple. The defendant allegedly admitted his guilt at his change of plea hearing, and in his pre-sentence investigation report, he denies committing any crimes. Therefore, the plea is rejected. It's simple. Matter set for trial. And if the defendant is convicted, he'll be sentenced. And if he's found not guilty, he won't be. Please rejected. Let's set the matter for trial. When will the parties be ready to go?
Let's give us a day, Judge. However, I would like to put something on the record concerning the PSI.
Of course you would, because your client screwed up this plea royally. But that's right. Try to fix it. Good luck. Hi, other Kelly.
And in what transpired. I had an opportunity to spend just some time with Sam going through what took place. And what he told me made a lot of sense. I think that in that section where the portrayal of what took place was written down, there was some significant miscommunication. So specifically, Judge, 4 lines down, where the probation officer in quote says never made threats towards the victim. He said that in relation to the fact that after the car ride that they were in, he did not make threats to her, but the threats were made when they were in the automobile. That's the intimidation. The other things that were mentioned in there were all about the dismissed counts. So I believe that it can be repaired.
Well,
however,
it may be, but not today.
Yes, and I explained that.
Because the way that I read the word never means never.
Sure.
Never means never happened.
And Judge, this is the
reason. You
reason.
have to say never ever.
Right. And this is the reason why.
No, you have to say never ever. Because sometimes we're just a little bit full of drama and we say, you never listen to me, when obviously the other person listens sometimes. So you have to say you never ever if you really mean never. It's a rule. You're a judge. You should know the rules.
I've gotten into a little bit of heat with some of the other courts, but I put down in my letters to my clients before they meet with probation officers, You don't tell them what happened.
I
Just say,
stand by my plea.
yeah, please refer to the probable cause affidavit. And in this situation, this is the picture perfect reason why I tell my clients that is things can get twisted. I mean, this is a long defendant version when he made it very clear
Never
in court
misleading.
when he pled guilty that he in fact committed the offense of intimidation, not any of the other charges. So,
I'm not
Judge, we can get
saying,
it set for trial, but I would like a status date in between so I can speak to the state and we might be able to get this repaired.
well, and that may be, but we're not going to try to fix the problem, or we're not going to fix a factual basis today. We
Right.
have other matters.
Sure.
This matter is set for a status, not a final pretrial, set for a status January 24th at 10 o'clock. It may be that it's possible to reestablish a factual basis and white out, that's not the right word, but explain what.
White out your computer screen, guys. White it out. Brad, I know it's not true, but that is just terrible. Because really, there are professionals out there who do this. Professionals. And it's really nice to sit there and watch professional play court clips. You should try it. Lacey.
What is set forth in the pre-sentence investigation report. However, at this point, the plea as submitted is rejected. This matter is set for a status January 24th at 10 o'clock. I will
Yes,
see you
thank
then.
Okay. The next one I'm going to is sad. So if you are not ready for heavy, sad today, go away for 10 minutes. I think it's 10 minutes long. I'll tell you exactly how long it is. 13 minutes and 3 seconds long. And I just want to show you. So, like, when I'm gathering court clips, I get like at least 7 of these a day. Yep, where the children are the victims. So, if that is too much for you, go away for 13 minutes. I just want you to know, I just want everybody in here to know this is what happens to them. This is what they get. They don't get 8 years on probation. When I see these cases, these are the outcomes. So it doesn't go into it deeply, but it does, explain why what's going to happen is going to happen. So it's starting now. 13 minutes and 3 seconds. If you don't like it, go away. But it's just nice to know that this is what happens.
Whether it's true or not, and it's probably true.
I cut out everything. This is just the judge's ruling at the end. I cut everything else out.
It doesn't matter in that what Mr. Sanders said is, I was abused myself. And if that's true, I am sorry that that happened. But that's not why we're here today. Why Mr. Sanders did what he admittedly did and how he got there is not why we're here today. We're here to sentence Mr. Sanders. Mr. Peterson said, when asking for a 35-year sentence, that 2 of the purposes of incarceration are punishment, which is true, and protection, or no, deterrence, to deter others from doing this. In my view, he left off the most important factor in terms of incarcerating someone, and that is protecting society from someone who's dangerous. And I understand Mr. Sanders, and it may be true, is explaining why he has done what he's done. But I don't really care. It's my job to protect others from being harmed from people like Mr. Sanders. What Mr. Sanders said and what Mr. Charkaloff said is people get abused, and when they get abused, then they abuse other people. So it's time for the abuse to stop. I know of no better way to stop the abuse than to sentence Mr. Sanders to the maximum that I can, and that will protect society while Mr. Sanders is in prison. And it's not that I'm not taking into consideration Mr. Sanders' background, but I'm taking into consideration what he did. The law requires me to set forth aggravating factors and mitigating factors. I take into consideration the defendant's criminal background. And what Mr. Charkaloff said is, well, he only has one prior conviction for something like this. Well, from my perspective, one is enough. And that the defendant served a sentence and was released from prison according to the documents that I've seen from September 9 of 2015 for a crime of sexual misconduct with a minor. After that, the defendant was charged with failing to register as a sexual offender in Lake County, Indiana, as well as failure to register as a sex offender in Mason County, Illinois, and charged with domestic battery in Elkhart County, Indiana. So what does that criminal history show to me? That shows to me that Mr. Sanders had previously been convicted of sexual misconduct with a minor and then twice charged with failing to register as a sexual offender once he was released from prison. Then he was charged with domestic battery. So what does that show? The criminal history shows that Mr. Sanders is now a repeat child molester. And he has allegedly battered someone who lives in the same household. Mr. Sanders' criminal history is a factor that I consider as an aggravator. The other aggravators that I consider are that the age of the victim in this case, she was a little child. And Mr. Sanders makes reference to other family members without getting into names or ages or who those people are. But this victim was a little bitty girl. And hopefully she doesn't remember what happened. And the defendant also
She was 3, so we'll see.
Recently violated conditions of probation, parole, or community corrections. The plea itself also says, as part of the plea, that the state is withholding filing charges on a similar case. But for this plea, it appears that that case could have gone forward, and if the defendant was proven guilty beyond a reasonable doubt, would have been sentenced for that matter as well.
I see at least 7 of these a day when I'm getting videos for you guys.
The pre-sentence investigation report lists no mitigating factors. I do find a mitigating factor that Mr. Sanders did admit his guilt. If Mr. Sanders did not admit his guilt, I would reject this plea as too lenient. by admitting his guilt, it doesn't require the testimony of a child in court or the testimony of the child's father in court, which would just revisit the
Indiana.
trauma that had happened previously. So that is a mitigating factor. The court is no longer required to balance or weigh aggravating factors with mitigating factors, but clearly the aggravating factors clearly outweigh the mitigating factors. This plea is an argued sentence with a cap on executed sentence, the way that I read the plea. Based upon all of the matters that I set forth, I sentenced the defendant to 50 years in the Indiana Department of Correction, suspend 15 years, so the defendant is sentenced to 35 years in the Indiana Department of Correction. He is required to register as a sex offender and to submit to HIV testing pursuant to statute. The victim is to be notified of the results of that test. The defendant is a credit restricted felon and shall serve 87.5% of the sentence. The state has refrained and will refrain from filing charges in Porter County Sheriff's Department case 22-35327. The defendant's ordered to pay a $100 child abuse prevention fee, a $500 sexual assault victims fee. Restitution is not part of the agreement. The no contact order that was previously issued will continue through the term of the sentence imposed. Additionally, the defendant should
30 years.
have a psychosexual evaluation completed and pay the fees either within the Department of Correction or upon being released from the Department of Correction. The defendant is required to register as a sexually violent predator and will be considered an offender against children under Indiana Code 3542-411A. The defendant has received the benefit of the plea agreement in that I would have sentenced him longer, but for the plea agreement. And the only reason I accepted the plea agreement was because of the defendant's admission of guilt and not forcing the family of the victim to go through trial. And I understand, Mr. Sanders, your situation in life and how you got to where you are. And I understand that. My concern, the reason why I'm sentencing the way that I am is my concern is abuse has to stop. Because if you listen carefully to what you said, and I did, I listened very carefully to every word that you said. People who are abused are more likely to abuse others. So the abuse has to stop. And the way to stop the abuse is to have you incarcerated. Given the length of your sentence, and given the fact that you must serve 87.5% of your sentence, you're going to be in prison in the Department of Correction for quite some time. I hope you get treatment that you should receive while you're in prison. And I hope that you do well if and when you get out of prison.
Excuse me.
You will receive credit for 831 actual days. Mr. Sharp.
Would the court consider ordering that SOM program while he's incarcerated in the Department of Corrections, please?
As a condition of his imprisonment, if it still exists, or any subsequent program that exists within the Department of Correction. Mr. Sanders, I'd like to see you have treatment, sir. But in the meantime, my job is to protect other children from you. Do you understand that, sir?
Yes, sir.
Is there anything else we need to address?
Fellow advisement, Judge.
Mr. Sanders, you have pled guilty. As part of your plea, you have waived your right to appeal your conviction, but you have a right to appeal the sentence that's been imposed. Do you understand that?
Yes, sir.
Would you like to appeal the sentence that I have imposed?
Could I have one moment?
You may.
He says no, he's not going to appeal it. So he goes to jail for at minimum 30 years. If he messes up, then he adds time onto that. All right, look what Fozzie sent me, guys. If you were here yesterday, you already know what this is. What is this?
You're gonna need a bigger boat.
He just wanted to be on camera. No, that's my son. Our baby boy. He was especially rowdy last night playing Overwatch or during yesterday's stream playing Overwatch, and before I went live I had to keep yelling at him. Stop, I'm going live. Stop, I'm going live. So he tells all his friends, my mom's going live. Yeah, that was really good. That was really, really, really good. Now I'm disjointed. Okay. Let's go to this guy. I think the audio should be fine. I don't think it's gonna blow your eardrums out. Let's see.
Next, State of Indiana versus Brian Gillot, 46D03.
This, in fact, is a different judge than the last one. Equally cool, though. I don't know. The last judge is really cool.
2303 CM
Fozzie, thank you so much for that. That was really cool.
826. Madam President.
No, he doesn't. He's not eligible for good behavior credits. Not with that kind of crime. They don't. So he is eligible for the 800 days that he already spent in jail for this, but he's not eligible for any credits while he's in jail.
He's reinactivated pre-child abuse.
All right. Are you Brian Gillot?
Yes, sir.
Home address, please.
104 Liberty Court, Westville, Indiana.
Date of birth
061366.
and how old are you now?
58.
All right. 6-month pretrial diversion agreement. It looks like it got extended community service. And then it got reactivated.
I'm not saying it's better, but the 3-year-old, not a whole lot happened. Something happened, which is enough, but nothing like you think happened to the 3-year-old.
All right, well, your domestic battery case is back on the table. Are you gonna hire an attorney?
I did have one. He just didn't show up. And I was doing the plea bargain, but I asked the question last time, so it got canceled while we were in here in court. Cause I signed the paperwork and everything. So when I asked the prosecutor a question during while he was talking, you put it to trial, Your Honor.
Maybe something fashion based,
Oh,
Cause I made a mistake, asking a question during while he was talking.
The judge is thinking, yeah, that's something I would do if you start asking questions during your plea deal. I don't take the plea.
When you agree to everything.
I think we're past all that, right?
I'm speculating.
Yeah, you're probably right.
But he's a 2403 case invasion of privacy as well.
And, that, maybe that's the one that he's talking.
And last time I looked at the plea bargain, Your Honor, it said 20 hours community service. I already did that long time ago and turned in the paperwork.
Well, what you hear on today was the domestic battery charge for March of 2023. You were given a pretrial diversion agreement. We finished.
Yes, sir.
That case. And that was given to you in February. Then it was September before you completed the community service. Then you picked up another charge.
Invasion of privacy, I think, Your Honor.
I think you're right. That's why this got reactivated.
Right,
So
exactly.
let me ask you this, what's going on with the new case?
In South Bend?
I don't know where it is.
Well, the one in South Bend or St. Joe County, it's a plea bargain on the next
Narcotic?
Tuesday. It's set up for a plea bargain. They just gotta
Here's
do
the
it.
deal.
Yes, sir.
They've reactivated this case. Whoever's representing you, whether it's the person that did originally or somebody new now, you need to tell us that this case is back on the table.
I tried, Your Honor, but they get confused. They didn't know it was a continuance of the first one with the 20 hours community service.
You and your attorney's got to figure that out.
Yes, sir. They're just confused. That's probably why it didn't show up.
Then help.
I've explained it numerous times. I'm sorry, Your Honor. They just messed it all up.
Well, you need to get somebody to appear.
So the charge now, sorry,
Who is representing?
Philip Christ.
I'm sorry?
The lawyer's Philip Christ. It's LLC, Camper Law.
Well, better get in touch with them, tell them what's going on. Let's go to that, January 6th date. For status. If we have room.
May I ask a question, Your Honor? I didn't get my 20 hours community service because I was also getting confused on the cases. When I didn't complete the 20 hours of service when the invasion of privacy happened.
Remember when at the beginning he said he already did his 20 hours and he submitted the paperwork?
This is a conversation you need to have with your attorney, not me.
Okay, I would just want to know if it did show I
You
did
need to
the
have
20
this
hours.
conversation with your attorney.
All right, sorry.
I'll get you the information you need.
Okay,
Can't give you legal advice.
all right, sir.
All right. See you on January 6th.
Thank you.
State of Indiana versus Lexi Kirby.
Real quick, I think it's fixed now. Okay. It's not when I'm in full screen. When I'm full screen, there's a delay. Well, it's okay now. But when I go down in the corner, no delay. It's fixed down in the corner. Okay, let's go to... We did that. Okay, let's do this one. I'm thinking I have to run through the audio in my head first to make sure it's okay. Here we go. That's not mute. Guys, that's pause. I have to hit mute.
All right, Miss Arima. All right, my name's Judge Myers. You're here for a preliminary hearing regarding one count of a citation related to the charge of hit and run. Okay, we're going to be diving into the evidence a little bit, and we're going to talk about it, make sure there's enough evidence to proceed toward trial. Okay. State may call its first witness.
We call Trooper Lane Riley. Can you please raise your right hand? Do you swear or affirm to tell the truth of the matter before the court, and nothing but the truth, so help you God? You have a seat. Can you introduce yourself to the court?
I'm Trooper Lane Riley. I've been posted here at Cumming, Post 37, since September.
And are you a Pulse certified police officer?
Yes, sir, I am.
All right.
Coming, Georgia.
And you said you work for who?
Be the Georgia State Patrol.
Thank you, sir. And were you working in that capacity on October 19th, 2024 at or around 11:37?
Yes, I was.
Were you in full uniform
Yes, I was.
and in marked patrol car?
Yes, sir.
Did you happen to run in or have an encounter with the defendant?
On that day, no.
All right. Can you explain why you wrote the citation for hit and run?
Yes, so I was called by our communications to go work a crash that occurred in Dawson County off of Power Center Drive. When I arrived, there was a tow truck there, just one vehicle and a witness.
You're single, huh? I wonder why. I need to know why. I need to know what happened. What did you do? What happened? Just kidding, Snoopy. You are adorable. Tax return. You mean you require someone to have a job? That's just not right. That's just kind of rude. Let's see who was gifted memberships. Thank you, Louise. Thank you. Thank you. You gifted all of France a membership? That's crazy. Another Kelly was gifted a membership. We have too many Kellys. No, we can never have too many Kellys. Now Terry's on the other hand.
So the driver of the tow truck was at one point an occupant in that vehicle, and at another point he was a pedestrian. He was attempting to repossess the vehicle that Miss Aremia was in. He did have a valid letter of repossession. From what he told me, he did not realize that she was in the vehicle. So he began the process of towing the vehicle whenever she woke up. She backed up over the equipment on his truck, which he had already placed behind the tires of her vehicle, accelerated out of the parking spot, and he stated that her vehicle knocked him to the ground as she was leaving. So the witness corroborated this as well. The witness was across the parking lot, but he did say that he heard yelling, looked over there, and he saw her vehicle bouncing as it was in reverse, as it was making contact with another vehicle. And then he saw Miss Aremia accelerate out of the parking spot and knock Mr. Corbin to the ground.
Thank you. So the vehicle actually made contact with the driver of the tow truck?
Yes, with the pedestrian as well. So the next day I was called to Dawson County Dispatch, alerted our communications room that they were out on a stop with
And
Ms.
hit
Aremia.
him.
So I went out there to follow up on the crash. She did place herself at the scene. She told me everything that happened, and so that's where I got my probable cause for the arrest on hit and run.
What'd she say to you?
So Miss Aremia stated that she was avoiding an illegal tow. That was why she backed out of the spot. She said that he was blocking her way. She said that he stepped or lunged in front of her vehicle as she was leaving. You know, I can understand wanting to get away from a situation if you don't understand what's going on. If you're asleep in your car and you believe somebody's trying to steal your car or do something to you. But I believe that a reasonable person would then contact 911, say, hey, this just happened. I did make contact with another person's vehicle, made contact with another person's person, and I was afraid that somebody was going to be stealing my vehicle. I just don't understand where the disconnect was between contacting another.
I'll send you my tax returns, but I'm going to need your medical records. I don't like commitment.
Another human being with your vehicle and then not reporting that to law enforcement.
So she said she purposely hit him with the vehicle?
She stated she did not hit him. She stated that he stepped in front of her vehicle or he lunged in front of her vehicle as she was leaving.
What did the defendant or the tow truck driver say? Did he think she purposely hit him?
Yes, he did.
He thinks that she swerved at him?
He stated that he had, where he was at, working the controls on his truck, and at one point talking to her, he was in front of the vehicle, and she was aware that he was in front of the vehicle, and she continued driving anyways.
And she saw him then make contact with him?
He was aware of his presence there in front of her vehicle, is what he stated.
What'd the witness state
Witness
about the
stated,
contact?
so a witness stated that from a distance, he did observe the vehicle contact driver number 1, the pedestrian, and knock him to the ground.
Did she say that she thought it was intentional?
I don't recall.
No, that's fine. Do you recognize the person you wrote that citation to in the courtroom today?
Yes, Ms. Ramey in the orange jumpsuit over there.
Thank you. And you said you were dispatched to Dawson, inside Dawson County, but is this address in Dawson County?
Yes, it was 321 Power Center Drive, I believe, at the Panera.
Thank you. And just to be clear, the portion that she ran over or backed over, was that attached to the tow truck itself?
It was attached to the tow truck, yes, sir.
Was the driver one inside the vehicle,
He was outside of the vehicle,
but next to it?
yes, sir.
Nothing further at this time.
Cross?
Yes, Your Honor.
Good morning, Trooper.
Good morning.
Not funny, Maiko.
When you later made contact with my client, was she driving the same vehicle that she was driving on the scene with the tow truck?
It was the same vehicle, yes, the tag on the back matched what I was given.
What was the tag?
Can't recall.
Okay.
Check my report.
Snoopy, Fozzie just sent me your picture, so I'm sending you my tax returns right now.
What was the make and model of the car again?
The Jeep Grand Cherokee.
What color?
Black.
Any estimate as to the year?
Your Honor, I would object to the relevancy of this line of questioning. This is a probable cause hearing for a hit run. Why are we asking about the vehicle?
Your Honor, this is a hit and run involving a car. I'd like to know what the car was and whether the car was properly identified.
And the question is valid. We'll see where it goes. If it's in the report, it's in the report.
Thank you, Judge. Trooper, did you have any estimate as to the year?
It was a newer model. Can't say the exact year just by looking at it.
Snoopy, maybe I'll find you a clip this week of a nice long prison sentence for DUI.
So, tow truck pulls up to my client's car. What direction is he pulling? Is this a tow truck with a trailer, or is it a tow truck with a hook?
It's a tow truck with a lift on the back.
With a lift on the back. And what direction was he pulling my client's car onto the trailer? Did he bind the back wheels first? Do you know?
So the vehicle was not there when I arrived. What I was told was he had already placed his lift under the rear, or the front tires of the vehicle. But I had no vehicle, no crash scene to investigate when I arrived because the black Jeep Grand Cherokee was no longer there.
Did my client make any statements about which side of the car was towed first?
That would be the front of the vehicle where the tow hooks were placed. From what I understand from driver number one's statements, the vehicle never made it onto the tow truck. He had deployed his tow hooks, lifted them, was preparing to tow the vehicle when she backed her car up over the tow hooks.
Did you check the Jeep for marks from the tow hooks?
Yes, I did look at the undercarriage. There are several scuffs I can't say as to whether that was caused by the tow hooks or prior marks and damage.
Where were the scuffs?
Would be on the air dam, just the undercarriage in general, behind the tires and up on the front end of the vehicle.
So only on the front end?
The undercarriage, yes.
Okay. Did you check the back?
No.
So you interviewed the tow truck driver. Did you check him for injuries?
Yes.
Were there?
To the ability that I was able to. He did not want to be evaluated by EMS. I noticed him limping. I didn't see any visible marks or bruising at the time, but it had just occurred as well.
Did the driver say what the limp was from?
From being struck by Ms. Remia's vehicle.
Did you ask him if he had picked it up earlier?
The limp?
Yeah, the limp.
No.
Just one moment, Your Honor. No further questions at this time.
Any redirect?
No, Your Honor, state rest.
Thank you. You can sit down. Any evidence for defense?
No, Your Honor.
Go ahead with closing arguments.
I hope everything comes out okay.
Judge will submit on the evidence.
Your Honor, as you heard, the victim believed she struck him on purpose. She backed out on purpose off the ramp, then drove forward and struck the victim on purpose. We'd ask you to bind this up as ag assault.
Your Honor, if I may respond.
I'll give you the chance to respond since it was a pretty big ask.
Your Honor, the evidence here shows my client woke up, she's being towed, she panicked. There's conflicting evidence as to whether she intended to hit the tow truck driver with her vehicle. In fact, Trooper Riley has testified that my client told him that the tow truck driver lunged at the car. Now that's a reasonable explanation for what happened. The tow truck driver, he's on a job, and he's got a job to do, which is to repossess the car. And his equipment's being messed with. He might lunge for that equipment in a panic. I think it's far more likely than my client intentionally hitting him with the car. I do not see any reason on the evidence that Your Honor has heard today to bind this up to such a serious, serious charge. If that's what the state wants to do, then the state should accuse it that way or indict it. Thank you.
Thank you, Snoopy.
Final.
Your Honor, I mean, the conflicting testimony was only the victim's statements, and she says she lunged at him. Regardless, we have a victim statement. This is a probable cause hearing. Probable cause. Victim statement stating that she purposely hit him with the car. We have an injury where he stated that he saw him limping. People don't lunge for moving cars in front of them, Your Honor. He's saying, oh, he lunged for his equipment. There's no equipment. She backed over it. It was in the front of the tow truck, as you heard the officer testify. She knew he was there,
No,
hit him
it's
with the
not.
car. Defense is, oh, he lunged in front of a car, jumped in front of a moving car. That's the defense. Your Honor, that's a probable cause hearing. We'd ask for it to be, like I said, bound over for ag assault.
I may, Your Honor.
Mm-hmm.
You know, a crucial element to aggravated assault is to have the intent to commit the aggravated assault as the crucial mens rea component. Clearly in this circumstance, given that she was unaware she was being towed and then she pulled out the vehicle, I don't think you have that element of intent. If you are inclined to have her, I guess, charged for something, maybe reckless conduct would be appropriate under these circumstances, since that has a criminal negligence component of it. So.
I think we're going to leave it at hit and run for the time being. I find that there is sufficient
forgot
probable
about
cause
this
for the hit
part.
and run, whether or not the state decides that they want to indict it further, or if they even want to bring for another hearing here. We're perfectly fine with that. So the case will be bound up to Superior Court for trial on the hit and run charge.
Thank you, Your Honor.
Anything else from council?
No, Your Honor.
I got that off my son's computer, and I uninstalled Avast immediately after that video. Now he has no protection on his computer, and he's a 21-year-old boy. I don't care. He's messing with my videos. If he gets a virus, I can fix it. Okay. Next. Okay. Oh, we're not going to have time for everything. Sugar. Okay. I guess this is our last one before Judge Fleischer. I have two more, but they're a bit longer. So is this one. I got this one because this guy has an outrageous ask of the judge that shocked me. Well, I mean, it's not, oh my God, shocking, but it's like, why? You can't do that. So that's why we're playing this clip.
I'm someone who tries to remind my wife that she's important to me every day. Despite that, maybe that's
Axe. He has an outrageous axe. He's gonna axe the judge something. No, it's not a screen shaver. Shaver. It's not a screen saver. It's what I'm gonna play next after I'm done with my clips. Psst. Psst. After he makes an ask, I'm gonna play Judge Fleischer like I always do, so I have it all ready. I love cabbage. I just love cabbage. I just do. And my children hate it, so I never get to have it. Anyway, this is, nope. There's a 50% chance it's Colorado. There's a 50% chance it's Texas. I don't know which one it is. E2 at
a little bit too often, more than necessary in her own eyes. But I would rather remind her of it every day and know that than I would to not do that and have her have any questions. So, also someone who tries to guide my kids in that good people are important, and that honor and integrity are actually more than just words.
Delicious.
And that hard work and loyalty should be admired, and that falling and mistakes, they're for everybody. And they happen so that you know how to get back up, and that you know how to try and do things better in your actions later. I work very hard to try and contribute to my family in any way that I know how to. Physically, emotionally, financially, anything doesn't really matter. If whatever they need, my kids need help with homework, I'll try and learn with them. If they need help fixing a bike, I'm going to try and show them how to do it. If they need cheering up, I'll probably make a lame joke that I'll be informed was lame later. Yeah, and if everybody's off in their separate rooms spending too much time on their devices, then I'll probably try and start a family game of cards or a saran wrap ball or something. But my point is that family is actually my world. So I just wanted to bring that to your attention. That's never been brought up. Yes, I did. I ran from these consequences of that day. Very much so. For multiple reasons. Mostly because I was scared. At the time, one of the reasons is I could not afford counsel at the time. And I honestly didn't believe that I would receive fair proceedings without it. And I know that's not a very good excuse, but I do believe that my attorneys have brought up several key points to kind of solidify some of those beliefs as well. I panicked and I left, definitely. And the situation did follow me in more than one way, and it has been a weight. My own doing for sure, but it's been there. I've never argued that it was anyone other's reason than my own. Aside from being able to now afford counsel, running has only harmed my case. It was definitely not a wise decision, and it did not support my innocence of the allegations that's been placed against me in this particular case. You could say that I kind of let fear rule a good section of my life for a while there. That day, I did. I made a terrible mistake that day, and it was a horrible event for all who were involved. I've been informed that I am not to address Ms. Bilyeu directly, but I do want to say that I did not know that Ms. Bilyeu was getting out of the truck at the time when she did, and that I am sorry that I had to harm her. I did not wish to harm her, and I didn't wish to harm her in the past, and I don't wish her harm now. I am sorry for the harm that I did cause that day, and I just, honestly, I hope that these proceedings and these events here will sort of settle the matter, so to speak, and that she can get something that she feels that she needs from this to help her find a sort of closure or an ending that she feels that she can move on with. We were definitely a toxic relationship. They were no good for either one of us. I do wish that we would have done something about that sooner, but we didn't. And I have my fair share of blame on that too. The belabored video call that was from January of 2011, about 14 years ago now. I have changed. I have grown a lot since then, believe it or not. And the statements that I made that day, blaming and belittling Mrs. Bilyeu as a person, was pretty ridiculous and misdirected is probably to put it very lightly. The joking manner in which that me and my father were doing at the time and the minimization of the situation was, I don't know, a fleeting attempt at grasping some sort of what's left of power, of control or power over my own life, which was dramatically changed at the time and for the worse, for sure. That desertion was an attempt, a horrible attempt, and it was at the expense of Miss Bilyeu. So again, something that
he absolutely can't be here right now, Micah, or he would have been all over this one.
I should apologize for. I was in my 20s, you know, and it is unfortunate, but I was not so smart at a lot of things back then. And despite, had you have asked me at the time, I would have told you that I already know, because, you know, when I was younger, you couldn't really tell me anything because I already knew. And strangely enough, amazingly, years later now, I don't really know squat, which is weird because 20 years ago I knew everything. I watched that video today or recently, and I am left with a level of disgust and kind of shame at myself. A shame that I couldn't properly even describe to you, actually. So I do wish that I had done things differently, and I do wish that I had been more mature or more.
Hold on. What do you mean by gravy so thick your spoon will stand up in it? That's too thick. I love thick gravy, but that seems a little suspect to me. A lot suspect.
More mature enough at the time that I could have handled it differently. But again, I didn't. So Miss Billy was a unfair target for, I'm not sure what I call misappropriated and twisted thoughts and anger at the time. And I am very sorry about that as well. And the last thing I would like to address just quickly, Your Honor, is and I know that there's no law or proceedings that provide for this, but I actually would wish that there was a way for you to actually just sit and talk with me for a while, just for a little while, so that you could
Abso-freaking-lutely not. You can't just sit and talk to the judge. What is wrong with you? Have you never watched Perry Mason or anybody in court? Judge Wapner?
so that you could ask me questions, so that you could hear my answers, so that you could see my reactions, so that you could witness and watch my mannerisms, and all just so that you could actually get a real feel for just a little bit of who I am, of some sort of sense.
Thanks for helping Fozzie with that video. It was amazing. Thank you both.
I don't know, because if you did, you, despite all the stories that are told about me here, and I understand them, I might surprise you with what you would find, actually. So I think that's about it. I want to thank you just for your time, for allowing
Snoopy, do not ask the judge for her tax returns, okay? Just don't.
me to speak and for any consideration that you put forth to me. So thank you.
All right. Thank you, sir. All right. So there's a basically agreement here that this would be a prison sentence at this point. Probation does not recommend a probationary or community sentence. And community corrections did reject him, I saw, as a consideration. So going through, basically what's before the court is a sentence range of between,
What did you do?
I guess up to 6 years in the Department of Corrections, given that that's the maximum aggravated range and there was a stipulation to aggravation. So the purposes of the code with respect to sentencing are to punish a convicted offender by assuring the imposition of a sentence he deserves in relation to the seriousness of the offense. Here we've got a very serious offense because obviously the results were terrible for the victim. And also because this was not a first offense. I don't remember if the first one involved the same victim. I believe that may have been a different victim. We've got 3 separate really serious domestic violence offenses here, though. In 2007, 2011 was the case that Ms. Bellio referenced a bit, where he actually did go to prison for the 6 years.
Fight that good fight. I want to know.
And then this case, there was some mention of the statement, both by the attorney and then both attorneys.
I did that once.
And Mr. Fields about
So
the
did
statements
Bill.
that, the statement that would have been allowed in this trial relating to, typically we don't
I think it's domestic violence. I don't know.
hear about prior offenses at a current trial, but in this case, there were statements that would have come in because they related to an element of this offense in that he did, and this is what he was referring to. He basically talked about that he would kill her at some point, that he would snap her neck. I have to say that the problem I'm having with the repeated things about it being a joke is it didn't sound like a joke to me. And I've had to listen to that a few times. Obviously, if it was a joke, it wasn't funny. And Mr. Fields understands that. I heard that from him, and I believe that at this point, but I also believe listening to it at the time that he meant it. To assure the fair and consistent treatment of all convicted offenders by eliminating unjustified disparity in sentences, providing fair warning of the nature of the sentence to be imposed, and establishing fair procedures for the imposition of sentences. And here, I think the important thing is that when we start having multiple domestic violence cases that are serious, it is consistent to send to a Department of Correction sentence that's fairly lengthy. Here, Mr. Fields, obviously he's making the argument that he benefit or the state, that he was harmed by negligence of the Bayfield Marshal's office, frankly, and the court just for you to hear, Mr. Fields, sanctions again with things like reduction of charges are things that don't happen very often. But it was deserved in this case. And I do believe that Mr. Fields is benefiting from that. To promote, and that largely occurred because he ran for a number of years, and it was in the interim that those items were lost. It was the Bayfield's Marshal's office responsibility to make sure that they were not lost, but nevertheless, that information was lost while he was gone. To prevent crime and promote respect for the law by providing a defective deterrent to others. And that's important for everyone to know that when you harm someone in a serious way, that there will be consequences that are severe as well. To promote rehabilitation by encouraging correctional programs that elicit voluntary cooperation. Here, he has been taking advantage of programs in the county jail. I sure hope there are programs at the Department of Corrections as well. He does seem like he's willing to work on rehabilitation in any way that he can to select a sentence, length of sentence, and level of supervision that address his individual characteristics and reduce the potential that an offender will engage in criminal conduct after completing his sentence. It does seem like Mr. Fields has grown up a lot and is understanding things a lot better. But again, the charges have been reduced substantially here, so I'm not sure that those might have been. I think might have had more impact prior to charge reductions, but here I think that I can't go lower than the 4 years looking at all these other factors, or the 6 years looking at all these.
Michael, I'm helping you. Fozzie, answer the question. We've been asking you for an hour now. Fozzie, we need to know. I'm going to get comments about pausing my videos. Now it's your fault. I'm going to tell them it's your fault too. Michael, I'll take that. I'll take that. It's delicious. It's absolutely delicious. Corned beef cheesecake. Yes, yes. Yeah, I'm going to get comments about pausing this. Oh, yeah. I love corned beef and cabbage. Oh my gosh, it's so good. I want some right now.
other factors. And one of them, of course, being to promote acceptance of responsibility and accountability by offenders and to provide restoration and healing for victims in the community. Here, Ms. Bellew is obviously very strong.
Judge Carlson, I'm pretty sure she's from Indiana. I mean, nope, Colorado. However, it just looks like Texas. That seal looks like some seals I see in other Texas courtrooms. And I'm just trying to zoom in. And I can't tell zooming in. It just gets more and more and more fuzzy. It just gets too fuzzy. State of, oh, I don't know. Does that say Colorado? It definitely doesn't say Texas. So it has to say Colorado. State of, that could be AC. It's Colorado.
Have come as far as she has, being able to speak here today. But this is the second time that he's, at least the second time she's talked about many offenses, but two very serious offenses that Mr. Fields has been convicted of against Ms. Bellew. So looking at all of the factors, I think I have to agree with Mr. Nagus that a sentence below the top range that I'm allowed to go in this case of 6 years would not be appropriate. So at this time, I am going to enter a conviction to count, is it count 5? Count 5, which is a vehicular assault or reckless count. And I will dismiss counts 1 through 4. He'll be sentenced to the Department of Corrections for 6 years, followed by 2 years of parole. And he will get credit for time served of 567 days.
Judge, I just want to make sure the minimus reflects correctly. So this was original count 1 that was amended by the district attorney's office in October of 2023 from second degree assault to first degree assault.
Sure.
And then was reduced by the court this year back to second degree assault. So then it was.
I didn't start at the beginning. I started at the last, because there were complaint that was pending when
the complaint was never amended correctly by the district attorney's office. When the charges were orally.
The record shows the charge he's pleading guilt, or that he pled guilty to, as count 5.
Okay. I just want to make sure that the Department of Corrections gets I mean, it's a class 5 felony. So, but I'm not sure the complaint was active for count 5 because charges were orally dismissed and never supported by a written amended complaint. So,
okay. So if you need to file a motion, you can, but Ms. Whitney, the current state of affairs is that the record shows count 5 is the count that he pled guilty to, and that's a class 5 felony, vehicular assault, reckless.
Okay.
All right. Thank you. We'll be in recess on this matter.
Yeah.
Nope, not a southern thing. We have it all over the place. Well, I live in Pennsylvania Dutch country, so we have a lot of corned beef. Yes, we do, and coleslaw. And sauerkraut, and coleslaw. Staple. My mom never made me. You aren't made to eat corned beef. You get to. Yes, we're doing an OJ today. Do not worry. I think I'm out of time. If I play any more, then I won't be able to play any of Judge Fleischer. So that's it. So we stopped about here. Nope. On Thursday, I bumped it forward till the next guy comes. That's it. That's all I did was bump it forward through the pause, the dip.
Hi, Troy.
Judge, I'm here on William Thompson.
Where's Mr. Thompson?
He is.
Come up, Mr. Thompson.
Pause. Everybody pause. Okay. Anybody who sees this video before 10 a.m. Eastern Standard Time, guess how many people we're going to have in chat today? Take a guess. Put a number in chat, in comments, to see who gets the closest. So our record is 1535, guys, right, Maiko? Nan? 1540? 1,500 and change is our record. No, I'm sure it's, but chat goes away. I can't come back to chat and say, oh, you were the closest, because you guys are all putting it in chat. 1642. I'm gonna go with Nan. Might go. Sorry, but I love you, but 1642 is our current record. Okay, you can't put the number in this chat because I am not scrolling back through this chat to see who is the closest. You have to make it a comment on the video if you want it to count. So we're going to see, okay, Mondays we get a bunch, Fridays we get a bunch. I think Mondays are the best day in his courtroom because it is the craziest. He says it's Fridays. That's not what I see. I mean, he knows it's his court, but I'm going to argue with him anyway. Were we, though? I don't know. The most I remember, well, you know, I'm going with Nan. I'm going with Nan. It was 1642. She would know. Yeah, but you're one person. She's Nan. You know what you did 3 days ago that you weren't supposed to? She still knows about it. She wasn't even in your state, and she knows what you did. So, nope, I'm going with Nan. Nope. No, nope, it was not 1492. Columbus sailed. Never mind. Nan doesn't make stuff up. Even if Nan's wrong, I'm going with her. Even if I know for a fact she was wrong, I'm going with Nan. Hey, Nan. Quick question. What's your first name? Nan, what's your first name? No, Donald, don't start with that. Don't start with that. You're right, though. I mean, you are right. All right, let's go back. Try to put in a comment how many, okay, you're a living, breathing man, the name of the person you represent when you're traveling. We're going to see who gets closest to the viewers in Judge Simpson's court. Put it in chat. Not in chat, in comments.
I don't have the paper here.
Drunken, that's just mean.
This was the one we were emailing. He was on for today. And then
She put on for tomorrow, and then I guess I sent an email to keep it on for today. I guess I never got it.
You have the case number?
No, do you mind?
252-8814.
That trial case we had, Judge, where we came to that global resolution with Fort Bend's DWI court.
And now you have bond violations. You have an open.
Man, you are so freaking cute. You know that. You are so cute. I can't stand it sometimes.
DWI here. You have an open DWI in Fort Bend. And now you have bond violations.
Judge, I think we can explain. Yeah. Judge, he works for Mattel, the toy company, and his shift was starting at 9 o'clock, and the company changed it. It sounds like quickly changed it to 6:30 a.m. Takes him about 45 minutes to get there. I have his logs where he's logged in showing 6:30. His granddad is driving him to work. It takes about 45 minutes. My understanding is he communicated with pretrial about the need to get to work or that he went to work. And hopefully it would, if we had the GPS data, it would show that he went from his home to his place of work straight.
Any other violations?
No, Judge.
So what are the timing violations?
It was an unapproved week, so he left early at 5:41 in the morning, and his curfew is at 6, or he's allowed to leave at 6.
Okay, that's it?
Yes, Judge.
Okay, I'm not gonna ding you on that. Just,
We would like to ask you to consider making it from 6 a.m. to 5:30 a.m. Would that allow you to get to work by 6:30?
yes, I'm okay with that, Troy. I mean, if it's just a matter of trying to get to work and that's the nature of the violation, I get it. But come to us first. If they change your duties at work, if they change your time at work, you got to come and let us know so that we can change it for you. Don't just start doing things on your own because then things go haywire. You have to answer up. So I'm okay with you going to work. I'm okay if you need more time, but ask. Okay? And you want 5:30 in the morning?
Yes, Judge.
Okay, you got it.
And so we thought that setting in Fort Bend was yesterday. We thought it was going to be on 12/4. It's on 12/20. He's supposed to be entering into a DWI program. It looks like there's some steps I'm trying to keep up with what.
Want us
he
to
needs
set it the
do.
day after that day or the couple days after?
Beginning of the year. I mean, do you have I don't mind coming back
I-
if you have dockets.
Yeah, we don't go anywhere. We're here, so I would like to hopefully end this before the end of the year. That way he's in the program throughout the holidays. That way there's no temptation, throughout that time. So what day in Fort Bend do you have court?
December 20th.
December 20th. Okay, so why don't we set it? That's that Friday. So if you want to set it the next week, any day. Not Monday though, because I'm going to be gone that Monday, but any other day other than that Monday, I'm okay with. Yeah. Okay. All right.
And any chance he can drive, Judge? He has the interlock device, right?
Yes, I have one.
I'm not. No. Don't push your luck. You have 2 open DWIs. I'm not letting you drive. No, you scare me, dude. No. And it's nearing the holidays. Get in the program, and then we're done here. Right? You're off mine. I think this case gets dismissed, right?
Yes, sir.
Once this case gets dismissed, you're under no
so
more of
do
my
I.
jurisdiction. You can do
Yes,
whatever you
sir.
want, right? So it's an incentive to get you to work this thing, to get this thing done once and for all. I mean, you're literally in the home stretch, right? You got what? About 2 weeks, you're in.
All right.
Do what you need to do, get in. All right?
Yes, sir.
Okay, guys, good luck. Hi, Ben. Yep.
I'm here on behalf of Mr. Naylor this morning with Mr. Jones, Your Honor.
Come up, Mr. Jones.
Mr. Naylor is in Cancun until Monday of next week, Judge, so he's not available this morning.
I
So I'm kind
understand.
of filling in. I have had a chance to look at this violation report regarding missed blows. I'm assuming that's our issue here today. Spoken with Mr. Jones about that. Pressed upon him the need for perfection here.
This is no tolerance. Absolutely.
Think about it. There's no downside to that. I barely have to do anything at all, and I get corned beef. Okay?
Absolutely no tolerance because we've had one issue after the other. Testing positive for here, doing that over there. We've literally let you go over and over and over. And there's absolutely no excuse for the missed blows. How many missed blows do we have?
That's 19, Your Honor. That's 7, within that 7 are included. But Judge, I would ask if possible, as I'm not the lead on this case, and I know Justin has had history with the court and Mr. Jones here on this case, if you would consider holding on the consideration of this matter until he returns on Tuesday of next week. So that he can
I'm
do-
sorry, Ben, I can't. I have to know, you have to know that we mean business. I'm not here to toy with you and play games with you. Know what the expectation is in this court. You've been with me for as long as we've had. You're over there.
Because I have a cold, y'all, cold weather. I apologize. So can I please speak on the breathalyzer?
No.
Just
You know
last
what the expectation is. You have 19 missed tests. That's it. I'm sorry, Ben, I can't. You're here and instead you're a capable and outstanding lawyer. I have the utmost respect for you, but 19 missed tests are 19 missed tests. And I've been telling him since the absolute beginning, there's just no tolerance.
Please,
No.
But to his credit, Your Honor, we have no positive UAs. He's been here on weekly UAs, so there's no indication that he's using this to obfuscate and for alcohol.
Sleep early.
Test, and he is blowing outside the window, so we don't know what he's doing.
Oh my God, sir, I go to sleep at 8 o'clock every night, sir. It's just the 10 o'clock ones, and I get my 5 o'clock ones first thing in the morning, Your Honor.
And you come here and you ask.
Oh, they just told me about this last week in pretrial over there, and they said that I have a 45-day miss.
You have 19 missed blows, dude. Covering the camera.
Please, Honor. I will do anything. I'll even go on that drug, ankle I'll do anything, Your Honor. I'm really trying here. I swear to God, I will do anything you want me to do if you just please let me stay free. I swear to God, Your Honor, I'm really trying here.
What?
Please, Your Honor. It's just I don't even drink.
From the 15th of November, you have been skipping tests. You have been to this court.
I go to sleep at 10 o'clock and I still did the ones later on when I do wake up. And they told me this just last week, Your Honor. I swear to God. I swear on everything I love.
You know.
Please give me a chance, Your Honor.
Testing schedule is, and I've given you one pass after the other. He goes with you. No.
Oh my God.
Your Honor, may we discuss setting a new bond for?
Of course.
Oh my gosh. Why? Please, I'm trying here. I'm trying to do everything.
Goes with you.
Oh my gosh.
Bond is at 5,001 now because of the prior violations. I'll now set it at 10,002. I'm sorry, Ben, but he's tested positive literally over and over and over. He continues to test positive for marijuana. When I've told him to stop, he's tested positive for opiates. He's tested positive for this. Now he's skipping blows. He has obscured the camera as well?
It's not necessarily that he's obscured the camera, but it's too dark to view it. It doesn't mean that there's.
It's the same thing. If we can't see you in the camera, then you're fooling. And I'm done with the fooling. That's it. I know that Dustin's gonna be pissed, but I mean, I've got it in black and white. And Dustin knows that it's no tolerance.
Consider 7502, Judge, for bond.
Okay, Ben. Okay. Great. But he has to know that we mean business, man. If I let him go now, I'm enabling, and I'm not gonna do that. I can't. But fine. Because fine. All right, 7502. Hi, Dan.
Happy birthday, Lights Rage. Happy birthday.
Yes, sir.
So I came in on Monday for a case that we reset to next Thursday, and we all agreed on it, and somehow showed it back on docket today by mistake. I don't know how.
Don't worry about it. Just ask them and then.
They told me to approach it. Thanks, Judge.
For sure. Herman. Hey, dude.
I have Mr. Anges Juarez. He's gonna do a PTI in your court with the dismissal of his felony, Judge.
Okay. I guess he needs a mitigation packet,
No, he's already been approved.
even on above a 0.15?
It's been approved, yes.
Okay, great.
Yeah, and then once he goes in here, he'll dismiss the felony.
Okay, so we'll give you 30 days. He's got to be here at the next setting with the packet turned in, and then we'll send it for TRAS.
No packet, TRAS are already set up for and everything. No packet needed.
When's your TRAS set?
December 18th.
Okay.
Yeah.
When do you
And
want?
January 10th, felony pending, so if we can get it the same day.
Done.
Cool, thank you.
Yeah. Hey, if he doesn't show up for the TRAS, we'll have issues though.
Oh, yeah,
So
absolutely.
just-
He's a Spanish speaking cool guy. But not this one.
Guys, Fozzie's yelling at me again, and I didn't even do anything wrong. You see what he's doing? Oh my gosh, remember this banner? Mike, poor Michael.
I spoke with the prosecutor about an alternative BTI.
No, no, she's got to get her GED, dude.
She's working on it. She's doing the classes.
Let's see.
She sent me an email from,
If anything, have you done for your GED?
And what I did for it,
What have you done?
I went to a class.
For me lately. I tried. I put effort in. Isn't it the thought that counts?
And then I tried to go yesterday. They canceled it, and he also.
You went the day before court.
And I also went before.
Judge, she's been going. She's been going before even the last court date, and we
Prove it.
I can take it.
In this life, you are only as good as the proof that you don't have. If you don't have proof, you have nothing. Spoken word means absolutely nothing.
Judge, the instructor, I got an email from him that she sent me saying that she's been going to the classes and that class was canceled on the 4th yesterday. But she did, attempt to go to the class. So she's been going, she did already take a test, and this is one where she did fail the first test. So she's been working on it. It's not enough.
I mean, here we are. How many resets have we had? We've had.
I said hello to Charlotte. Did you miss it? You should rewind.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11 resets since May. You're now in December. You have had 5 to 6 months. Show me the money. Otherwise, it's not going to go well for you today, Ms. Dixon. Show me. 5 to 6 months.
And Judge, this was a case where she was paying for the classes and then she had to then enroll into the free program, which she's been doing for the last little bit.
Are you playing Candy Crush? What's going on over there?
I'm trying to text him.
Texting who?
The instructor, like what I'm supposed to show you. Cause I don't have no proof, like I don't have nothing.
Tell me what have you done?
I went to the class,
Okay. Which class did you go
the
to?
GED resource.
Okay. And what, because the way I understand it, there are different modules that you do. You do science, you do language arts, you do math, you do, and whatever else it may be. You go through each section, you complete it, take a test, and then when you're done with everything, you take an overall test, and then you get a diploma.
That's not.
What have you done?
Basically explaining on how everything's gonna go, and I was gonna finish everything else Wednesday when I was gonna go, but the class was canceled.
Who is the provider that you have?
His name is.
Grab me a phone number, because I'd like to call them right now.
I have literally said it twice on this stream now. Twice I've said it. Twice. You can rewind and hear it 2 times. Twice. Wait, you never ever listen to me. You have to put the ever on the end, guys. Remember, the judge said. Bonjour 3 times. But you know, Charlotte, I'll say it to you all day long.
I have a number for you, Judge.
Oh, Charles Jackson.
I had coffee. Now my computer works. I used to play Candy Crush all the time, but I haven't in a long, long, long time.
Mr. Jackson? Yes, my name is David Fleischer. I'm a judge here in Harris County. And I have someone that's with me in our court, and she's doing a program with you guys to try to get a GED. I'd like to confirm that's Coriel Dixon. So Wednesday and Thursday, and then did you say every other Saturday? Okay. And then, so how does it work as far as getting the diploma? Do you do different classes as far as science, math, and how do you at the end get it? Can I put you, I have her in front of me. Can I put you on speakerphone so that she can hear this as well? You mind?
He always calls
Okay,
me
hold
when
on.
I'm in stream.
So I've got him.
Kelly, that's a great question.
Okay.
When is it going to be? I don't know. Got to squeeze in a second to do that. It's good.
Mr. Jackson?
Order in the court, please.
Okay, tell me, how goes it?
So, yeah, it's kind of twofold. They take an assessment. Based on that assessment, allows me to know where the student is as far as their grade level in math and in reading. Based on that, they go on 2 tracks. And so one track is like a basic education where we're just literally working on kind of some elementary reading and math skills.
Okay.
Or a GED track where they're ready for GED contests. And so, yeah, and I usually just, go from there. I work with my GED students individually. And
How long does the process take? And how long can we expect it?
well, so that's honestly kind of a loaded question, depends on where they fall. I believe Coriel scored pretty well.
Great.
So, yeah, and, I've worked with people that have gotten the GED in 3 weeks. I've worked with people that have gotten the GED in 2 years.
Oh, yeah. I can't do 3 years. That's too much.
Well,
I know, I'm kidding.
understand that. No, I understand that.
She's been faithfully attending though? Yay or nay?
I don't
Okay.
know how it works.
Great.
And with some consistency, 3 to 4 months, maybe less.
That sounds great.
That's just me ballparking.
I'd like to stick with it because I think at the end of the game, our goal here is that she ends with.
I did my best to get Tommy here. I did. I really tried. I can't make her come at 4:30 in the morning though. I just can't.
That diploma. And I think that would be a win for everybody. I'm basically, I'm calling you. I want to make sure that everything's going well, that she's attending, faithfully attending and doing well. And it sounds like you're saying that this is what's been happening.
Yes.
Great. Okay, so I'm just going to continue everything. Just continue to go, Miss Dixon. I mean, you got like what he's saying, if you continue at it 2 to 3 months, you'll end up with your diploma. Okay. All right. Thank you so much, Mr. Jackson. I really appreciate your help. You've been great.
No problem, Judge. You take
Okay.
care.
You too. Thank you, sir. Bye. Great. Good job. Just keep at it. Okay. So let's set it 30 days. I want to ride this through. You're so close to being through. All you got to do is see it to the end, and then everything great will happen for you here as well. Okay. All right. Good job. All right.
Oh, that's so early. Oh gosh, that hurts my heart. I feel so bad for you people. So my plan was to start slow in the middle of the night and then move to prime time. But do not worry, I'm not going to. I'm not. There's too many people on prime time now, flooding the airways. I'm gonna stay right here. Although Fozzie thinks I should do more videos during prime time. Not my lives, or maybe short lives. On top of this, not instead of this. Judge, come on, call a case. Oh, Victoria's out. No one's calling a case because Victoria was out. Playing around in the courtroom. Shreya! That's not the mute button, Kathy.
Morning, sir.
Thank you for seeing me, Judge.
Of course.
Come before you. I don't really know what I'm doing.
CJ, you are the reason I have never changed times. Because you were so pleased that it was at this time. You were so enthusiastic that it was at this time. And I know people after you have also been, but you were the first. So you are the main, biggest reason I'm at this time.
I just know that I came before you and I was from out of state. You tried to help me and I was kind of telling you that it was going to be dismissed anyway. I was here 9 days. They shipped me to Arkansas for 30 minutes. It was all done. Set to be dismissed on the 9th. However, the police that stopped me had my car towed and put a card in my property. And so my car was sitting there the whole time. And so I had to find my way back to Houston. Since I've been having Uber back and forth to try to, and I couldn't get my car.
Nan, I love you. Nan, thank you. Thank you, Nan.
It was 540, now it's 1400. Look, you got 4 days, sir, and we're gonna auction off your car. But then they said, if the judge you went before, if he gives you an order, we will release your car, zero balance. Again, Judge.
I can't give you an order to give you your car back. That would be me, in essence, ordering a company that does business to lose money to give you your car back because you don't want to pay to get the car back.
I don't want them to lose money. The thing is, my car was towed erroneously. I was at home. That's why I want to show you the police report. I was at home.
To file a complaint with the police, internal affairs. If you're telling me that if something was done illegally, immorally, or whatnot, you need to file paperwork with that appropriate agency. But I cannot order a private company to return something to you. I don't have that kind of jurisdiction.
What do they mean you get a judge's order and we release it?
Maybe a civil judge's order. I'm a criminal court judge. The only time I can ever order any kind of property return would be
Capes gets sucked into the airplane, remember? I got to take one more pause because I just saw the cutest thing. The cutest darn thing ever. I have to show you. And half of you are not going to be happy with this pause. But some of you are going to be. Look. Isn't that so cute? Why didn't they have that when I had my little girls? Look, it folds up. Do you see that? Isn't that so? Sorry. I'm going to go back to the court videos. Oh.
If it's confiscated by the state and they're holding it. So let's say You get arrested, you get pulled over, and you have a gun on you, right? They take your gun and they put it in the HPD property room, right? In that respect, under certain circumstances, I may be able to order them to return it because it's in the care, custody, and control of the state via HPD. Here,
Do you read what you said there? Reread what you said there. Reread it. So if I still have to pre-record the video. It's the exact same amount of work. It just gets released at a different time.
your car was towed by a private company and they're holding it and it sucks. I get it that the bill has ballooned as much as it has. If you ever have a problem, you can always file a complaint with the bail bond, not the bail bond board, but there is a actual board for, there's a towing board too, isn't there?
I'm looking at it, yes.
It's a towing regulation.
There's
a request for a hearing, but I'm reading that it's got to be before the 14th day after the vehicle was removed, is that you have to submit a tow request. The forms are all here. It's 50.
And maybe the fact that you're in custody may toll. I don't know. But I'm not versed on that kind of, and I'm not, number one, number two, I'm not allowed to even give legal advice, but I don't know. But I can't order them to give you your car back. That would literally be me telling them, hey man, just forget about all the money that you've made by holding the car. Just give the man his property back. I can't do that. I don't have the jurisdiction. Maybe a civil court under certain circumstances may order it back, but you'd have to file a lawsuit. You'd have to file some kind of paperwork.
I've tried.
What I would do, perhaps, can you get on a payment plan with them and say, hey, look.
Try that.
You did to Santo, remember?
They zero tolerance. I mean, honestly,
And I have to understand, because imagine how many times they've probably gotten yanked,
I wish.
Theoretically, even if I were to give you a court order now, my guess would, they would hire a lawyer, file a motion to quash my order, saying that, hey, he doesn't have the proper jurisdiction to do this, right? And then they may come after you for attorney's fees. My
manager's like, hey man, if you go to it, I'll release your car to you. He understood what happened. He said, man, just bring me something. I'll release it to you. I'm like, okay, I'm gonna go try it.
And a lot of times they say stuff just to get you out, but I can't. I'm sorry. But like I said, perhaps if you talk with the owner, you may be able to negotiate something with them. If you talk with if you talk with someone who has no power to negotiate, you always, if you talk to the right person, if you talk to them at the right time, you may get what you want. So don't go to them at 4:00 in the afternoon because they've been working, they're tired.
Lassie can't find videos for me because my videos are not on YouTube. They're not there for him to find.
Probably dealt with a lot of people. All they want to do is go home, but go there first thing in the morning, try to get to the owner and say, hey, look, here's my circumstance. Here's the proof. Work with me. I want my car back. And I don't know, what do you think? Anything else, Freya?
No, I'll help him out with the tow lot information, and I also have got a copy of HPD's agreement with private tow lots, so that maybe that can help him.
Thank you, I appreciate it.
Yeah, I'm sorry. But, you never know, it doesn't hurt to try. But just keep trying it.
I'm praying for that.
Yeah, look.
Yes. Thank you.
Okay. Hey, Stephen.
Guess who's coming back to court today that we haven't seen in forever? Victoria. She should be in court today, right? I can't imagine her not being in court today. It's been so long.
Yeah.
People probably moved her stapler, and that's just so rude. David.
You want them in the middle?
Hey, shh. All right, good morning, Mr. Cordova. Sir, you're charged with driving while intoxicated, second offense. It's a class A misdemeanor. You're looking at up to a year in jail and or a $4,000 fine. Looks like they're going to reduce it to a first. You need to understand that it's still 2 on your record now. So after today, bless you, you ever get pulled over with the faintest smell of alcohol, dope, whatever it may be, what do you think is going to happen? What's going to happen? Not with me. From now on, you've now graduated to felony court. 2 and 2 make 3. A third DWI, you're looking at a third-degree felony, a minimum of 2 years in prison, a maximum of 10 years in prison. And I'm going to tell you that you don't have to be falling down piss-ass drunk where you urinated and puke everywhere. Just the faintest smell of alcohol. They're going to look your record. They're going to assume if it walks like a duck and it talks like a duck, they're going to just rather take you off the street.
Watch
They're not
the
going
window,
to try
it's
to be
coming.
cool and let you
Just
go.
watch out the
What
window.
happens if you kill a family of 5? That officer's career down the toilet. So in an effort to make sure that doesn't happen, they're just going to take you off the street. And you thought now was bad. Wait till you get to felony court. All you have to do is don't get into a car, even if you've had a sip. One button on a phone, $30 will take you wherever you want to go in this life. No matter where you want to go. How much money have you spent? I want you to know that you are now skirting, by doing this probation here, the mandatory 5 days in jail that you would normally be having to do. But I want you to understand that I'm going to hold you to this probation. Shh. And if you fail to do what you're supposed to do, I'm telling you now, I'm going to lock you up. And if I find that you have a problem with dope, you have a problem with alcohol, I can and will most probably put you in a rehab facility in the jail. Do you understand? No alcohol means no alcohol from any source, no matter how long, whether you're a month away from completing probation, whether you're 1 week. I can't tell you how many times people get back here because they say, oh man, I've got a month left on probation. I've got 2 weeks. They're not going to do anything. Boom, you get tested on the last week of probation. So get ready. You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law. You give up the right to appeal. Once you plead guilty, it will go on your record. You can never take this off. You understand? This is what you want to do. How do you plead to the offense of driving while intoxicated? Guilty or not guilty? I will find you guilty and I'm going to sentence you to 180 days in jail. I will probate that for 12 months. As part of the probation for you to successfully complete it, you must do a repeat offender DWI education class. You must do 1 victim impact panel, a TRAS, which is an evaluation to see what other conditions you may need. If they assess other conditions, you must fulfill that. It could be intensive outpatient treatment. It could be supportive outpatient treatment. It may be something else. If they assess something further, you must complete it. No drugs, alcohol, random urinalysis, guardian interlock, no breath test refusal. If you were pulled over in a car and an officer asks you to submit to a breath test, you must do it while you're on this probation.
Your Honor, if I may, Mr. Cordova has the scram and he'd like to keep that because he has hired a driver. We know it's a first DWI, but DPS, sometimes they may come back and do a hard suspension or 90-day, and we don't want any missteps. So
And
he's
what-
okay with that if the court is.
Problem is, I've been paying it for you now. I can't pay for it anymore. You're going to be responsible for this thing on your own now. That thing right there is $500 a month that I've been eating, so you don't have to pay for it. So I don't know how your finances are, but an interlock is typically, what, $100 a month? I don't know, but that, it's at least double, if not more, than what an interlock costs.
Can you afford that?
That's fine. I can't pay for it. I don't, while he's on probation, I can't pay for things.
And that's just my concern. If he gets the breathalyzer, he's not driving, then it's going to be a violation because he's not driving.
We do portable devices.
We tried that, Judge. I don't trust those. I've had a lot of, and I think he feels the same. There's been so many issues.
It's up to you. I'm happy, whatever you do, just make sure you maintain compliance. Don't stop charging it. Don't stop paying for it, because at that point, all we're going to end up doing is issuing a warrant for your arrest. $100 donation to the Houston Food Bank and 30 hours of community service. Give children. How many kids you got? I'd rather, instead of the community service, do a parenting class. I think people would be better served with doing a parenting class than just mindless,
I think that's very
dumbass work on the street. Forget about it. No, you're better served learning things in this life than to just do menial work. The idea is that you learn so that you don't come back and that you don't graduate to felony status, because then I'll tell you what, this is going to be hard on you. But when you end up with a felony on your record, it closes so many doors. It's unreal. You lose the right to vote. You want social services from the state. Forget about it. Not when you're a convicted felon. It just closes so many doors. So you need to do everything in your power to prevent that from happening. How do you plead to this? You said guilty. How do you plead? All right, I'll find you guilty. I'll send you to this agreement. One more thing is there are fines and fees that you're going to be required to pay. There's a supervisory fee that you're going to be required to pay for this DWI. It's a $6,000 fee. We will give you time to pay it. I give him 2 years.
We did discuss, he makes a good salary, but he's got 5 children. So I don't know if the court would consider waiving that or.
So what we typically do is we give him 2+ years to pay it, and it ends up being like $100 a month. Just don't stop paying it, What I'll do is I'll waive the court costs.
Fabulous.
Okay, so that'll take off like $500, but
Right.
you'll have to pay the supervisory fee. It's a lot, but we'll give you time to pay it, and don't stop, because if you stop, we will issue a warrant, and your butt's going to sit $100 for every 1 day for every $100 you owe. Hopefully this is enough to get your attention, because at the end of the day, you're walking out of here when you should be doing jail time.
Right.
So it's going to cost you a pretty penny, but hopefully that's enough to get your attention. You understand?
Sure.
Okay, man. Good luck.
Thank you.
Thanks.
Appreciate you.
Sure. Yeah, I have to suspend a license.
No, and that's.
I'll do it for a year, and then, show me that you're good. I'll entertain an occupational later on if he's doing well and in compliance with the probation.
Sounds good. Thank you.
6,000.
Good morning.
Hi.
Good morning, Judge. I'm here on.
We did it. I had 2 more clips, but they're so long. Don't worry, we'll get to them. I'm worried about the one because it's a little lawyery. It's a little legally. But with this legal clip, in legal terms, he choke slams the other attorney with words. And it's so good, but you guys might be bored by it, but it's so good. I'm going to play it soon, tomorrow, hopefully. But now I'm going to make myself a sandwich, and then I'm going to hop right into OJ. It's an hour long today, I think. Let me just look again. 53 minutes and 19 seconds is today's OJ clip. So please don't feel like you have to come watch OJ. It's a commitment if you're going to do this trial, or stay for a minute and look at the hair. Look at the hairdo. Hold on, I'm going to show you a sneak peek. Oh wait, I got to get this blonde lady. Oh, I lost her. Don't worry, you'll see her. But I'm going to give you a sneak peek of the hair. Of the 80s hairdos. Get out of the way. Yeah, that was me. The bigger the better. Victoria will be back. Victoria will be in court soon. If I don't get this trial, OJ trial started, then I'm going to be late for Victoria, and I will not be late for Victoria. No, sir. No, sir. Although I might come in at like 15 minutes late because all the highs at the beginning, I just can't, guys. It's just too many highs. So I wait until everybody gets it out of their system. And Maiko says hi to everybody, and Nan says hi to everybody. And then I come in and I just say, hi, guys. Which we all should just do. You walk in, you say, hi, guys. But I teased my hair the other day. I did. I sprayed it with a whole bunch of hairspray and teased it up. But that was a different story. Okay. Thank you so much for coming out. I really, really, really appreciate it. I'll see you guys in OJ, or I'll see you guys in Judge Fleischer's court, or I'll see you guys in Bill's stream, or I'll see you guys in my next stream, unless I fall asleep for any of that. Bye, guys. Thank you so much. See ya.
Got these lights that goes digital dreams through the screen, her blue eyes gleam. Wicked humor, sharp as a knife. Her stream sparks electric light. Late night when the world sleeps, she's the friend that always keeps. Giggles roll like thunder loud. She stands out in any crowd. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Freedom tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Her eyes near a sky so blue. In her jokes, there's a truth so true. Wicked stream, she brings the light. Turns dark days into bright. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no alarm. Streaming tales late into the night. Her laughter feels just right. Even when my world turns gray, with a giggle, she lights the way. Kathy's laugh cuts through the gloom. Eyes blue like a summer's bloom. Her humor dark and twisted sharp. In a way, there's no